It is 11:05 Dubai time in the morning, and we need to start this webinar. Good morning if you're in the UAE. Good afternoon if you're joining us from India, and hello to everyone else around the world. Thank you for joining us today. Galadari advocates and legal consultants are delighted to present this joint webinar with Link Legal, a leading international law firm with respect to the execution of UAE court judgments in India. I am Sergejs Dilevka. I am a senior associate at Galadari Advocates and Legal Consultants, the Dispute Resolution Department. I have more than a decade of experience in international investment and commercial arbitration with a focus on the Middle East. I regularly act as counsel and arbitrator in arbitral proceedings under the auspices of various arbitral institutions. I am also a registered practitioner with the DIFC courts. That said, this topic today is outside the scope of my expertise, and I'm as interested as you are to hear from our friends today at Link Legal with respect to this topic. I'm joined today by Namita Das, partner at Link Legal India, Abhishek Sharma, also a partner at Link Legal India, and my colleague Manish Narayan, a partner at Galadari here in Dubai. Now I would like to request the other speakers to introduce themselves, perhaps starting with Namita.
Hi, thanks. Thank you and good morning and good afternoon to everybody. My name is Namita and I'm a partner with Link Legal in the Delhi office. So I practice IBC, amongst other things, IBC, M&A, and also some bit of investments and aspects related thereto. Therefore, in that context, we are here today to present before this significant development in the laws on enforcement of UAE decree in India. Thank you. Look forward to speaking to all of you.
Abhishek, please.
Hi, good morning, everyone. Good morning, Manish. Good morning, Sergejs. Thank you for having us at this incredible webinar. My name is Abhishek Sharma, and I'm a partner with Link Legal and a part of its disputes practice. My work involves both court cases as well as arbitration matters. I'm also a part of the firm's IBC practice, both on the corporate and the dispute side, even though I lay greater emphasis on the court side of the IBC practice. And that is where Namita and I have joined synergies. We are indeed thankful to you for organizing this event, and I hope that we're able to add some value to all the participants who've actually taken out time on a working day to join this event. Thank you very much.
Thank you. Manish, please.
Hi, this is Manish. I'm a partner with Galadari Advocates. Very warm welcome to Abhishek and Namita, who are going to elaborate on execution and enforcement proceedings in India. My areas of practice are disputes, cross-border investments, and real estate developments. I also specialize in UAE court disputes and cross-border disputes between India, UK, India, UAE. Thank you.
Thank you, Manish. Now, trade and cross-border investments in the UAE and India are on an ever-increasing trajectory. Even COVID-19 implications haven't affected that much. Of course, economic activities do lead to disagreements, and some of such disagreements will inevitably end up in the courts, in litigation. Not all parties have arbitration agreements embedded in their contracts. Therefore, parties from different jurisdictions will also end up in litigation proceedings, including proceedings in the UAE courts. Believe it or not, even after a judgment has been issued and all the appeals have been exhausted, certain debtors and counterparties may still not want to comply with the judgment and pay what is due. Conversely, I think I speak for all of my colleagues here. We are yet to meet a client who is happy to incur costs to obtain an award or a judgment that they cannot effectively enforce. Thus, a formal and effective execution of a judgment is critical. I am told that execution of judgments is even more complicated than enforcement of foreign arbitral awards, and we will know about this more today. To my knowledge, there is no international or regional treaty that may be considered to be an equivalent to the Convention on Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention 1958. Especially, this is the case if the concerned states are not party to some form of a judicial assistance treaty or a reciprocating treaty. In this regard, an agreement on judicial assistance has been in place between the UAE and India since 1999, at least that is what I know. And India, until recently, has not been a reciprocating territory under that document. Apparently, that has changed since January 2020, when the government of India notified the United Arab Emirates that it is now a reciprocating treaty. And please do correct if any of these statements are incorrect. Since that time, we at Galadari have actually seen a considerable increase in queries with respect to potential clients and the possibility of executing the judgments that were obtained in the UAE in the territory of India, including against those who have absconded or relocated to India. Thus, the time is right, we believe, to have this webinar and provide some practical guidance to our clients, potential clients, and just generally colleagues on execution of UAE court judgments in India. In terms of format of the webinar, Namita and Abhishek are the subject matter experts that will take us through the process of executing judgments, UAE judgments in India. And Manish and I may, from time to time, interject with questions throughout the session. We are also happy to take questions from the audience, today's audience. In the last approximately 15 minutes of this webinar, there will be a Q&A session. And please feel free to put your questions to us during that session in the chat box. With all that said, Namita and Abhishek, over to you.
Thank you, Sergejs. So to begin with, if the presentation, if it could be projected on a full screen mode, please. Yeah, if we could go to the next slide, please. Yes. So today, like Sergejs mentioned correctly, over the past decade, the cross-border businesses have grown, more so between India and UAE. As is common to all business interactions, this growth has also led to increased cross-border disputes, which has further thrown up challenges for stakeholders and the judiciary alike on cross-border disputes and resolution and enforcement of decrees passed by the courts of one country in the other. In this context, to ease the enforcement of decrees passed by courts in UAE, a notification was issued by the Ministry of Law and Justice of the Indian government on January 17, 2020, notifying UAE as the reciprocating territory for enforcement of decrees in India under Section 44A of the CPC. Now, this is a welcome initiative, like already mentioned, designed to promote increased economic activities between India and the UAE. Now, what happens as a result of this notification is something that we will further elaborate and speak in detail in this presentation. But the key points is that it opens two options for UAE decree holders vis-a-vis enforcement of judgments in India. One is that the UAE decree holders can now approach appropriate courts in India in terms of the CPC and go for a direct enforcement. And also in light of the IBC regime of the Indian government, insolvency proceedings can also be initiated. Now, as we see that we would be covering this, the premise that we discussed just now would be covered by 4 agenda points in our presentation today. The first one being the key concepts. In this, under this forum, we will be speaking of concepts. In this forum, we will be speaking of concepts such as what does reciprocatory territory mean? Who are the designated courts from where, superior courts as they are called under section 44A. These concepts are very important for us to see how this notification and section 44A would be translated into practice and further enforcement of decrees can be initiated. Secondly, we would go into the process aspect of execution of decrees in India, where we would be discussing how does section 44A lay down the process, how can we use it, and also further the process of IBC as well. Thirdly, we would also like to give more context to what does this notification do to the enforcement scenario of judgments. We would be also looking at a case study on initiation of insolvency prior to a similar notification. And fourthly, we would conclude by a forward-looking initiative where we would talk about how jurisdiction clauses should be now drafted in agreements between India and the UAE in light of this notification. Thank you. And with this, I think we can move on to the next slide. Yes. So on the background aspect uh, of this notification, we would begin. We have to first understand what does Section 44A provide. Section 44A provides for the framework of enforcements of foreign decrees in India. In terms of this Section 44A, the Indian government enters into bilateral agreements and then subsequently notifies a territory as a reciprocating territory. The point to be noted here is that for any judgment from a foreign country to be enforced in India, there are twofold tests. One is that it has to be from a specified court of that territory. And second is the territory in itself has to be a reciprocating territory. Like I already mentioned, we would be dealing with these concepts further in detail in our subsequent slide. Now, further to this section 44A also, what it provides that there have to be bilateral agreements between the countries here, which will have the limited effect of this agreement and enforce, this will lay down the terms of enforcement also. Now, vis-a-vis India and UAE, like Sergejs already mentioned, there was a bilateral agreement which was executed in the year 1999. However, there was no, just having a bilateral agreement is not enough. We need to, as we already mentioned, Section 44A talks about a reciprocating territory. Therefore, the government of India needs to have a notification notifying such country as a reciprocating territory. In this case of UAE, although the agreement was in 1999, the notification only came out in January 2020. Now, what was the scenario before this notification is the bilateral agreement gave a long drawn process where there was, which provided for service of summons and other judicial documents or a process, taking of evidence by means of letter of request or commissions, execution of decrees, settlement, and arbitral awards. Point here is although there was a bilateral agreement, because of not having a notification, we had a long drawn process, which process did not facilitate a direct enforcement. Now, with the notification on reciprocating territory, what has happened is UAE awards can be directly enforced in India but the process as specified in 44A has to be followed. Now, 44A, like I already mentioned, provides that the order has to be from a superior courts. We will be looking at further which are the superior courts from UAE, which orders are eligible for implementing in India. Therefore, like we already mentioned, there is two tests of a superior court and a reciprocating territory, which both are being now met in case of UAE, and therefore the process of having direct enforcement for all disputes between business houses and parties of UAE and India becomes eligible to be directly enforced under the process of 44A. And also to mention, which we will also further talk about in the further slide, is that 44A also provides as part of the process certain prerequisite. What do you need apart from just being an order from a superior court from a reciprocating territory to enforce such order in India, which we will also be dealing in the subsequent slides. Thank you. I think we can move on to the next slide.
So, thanks, Namita. So as Namita pointed out, we'd be dealing with some of the key concepts which are relevant for the purposes of enforcement of UAE decrees in India. And to my mind, the most critical component, which will have a considerable impact on how a foreign decree shall be enforced in India, is the concept of reciprocating territory. Now, Sergejs already touched upon this. So as Namita and Sergejs pointed out, prior to the 2020 notification, which came around on January 17th, if I'm not wrong, in order to enforce a decree passed by a UAE court, the decree holder was required to file a fresh suit on the basis of the decree passed in the UAE court before an Indian court. Now, this fresh suit could be based on the foreign decree or the original cause of action, or both, because even the benefit of res judicata was not available prior to 2020. However, pursuant to January 2020, UAE has now been defined as reciprocating territory under Section 44, and certain UAE courts have been identified as superior courts. So the result is that decrees from any of these superior courts can be straightaway executed in India through Indian courts as if they were decrees of Indian courts themselves. The January 2020 notification identifies certain UAE courts as superior courts, and these are at the federal level, the Federal Supreme Court, and the Federal First Instance and Appeal Courts in the Emirates of Abu Dhabi, Sharjah, Ajman, Oman, Kuwait, and Fujairah. At the local levels, the courts which have been identified as superior courts include the Abu Dhabi Judicial Department, the Dubai courts, the Ras Al Khaimah Judicial Department, the courts of Abu Dhabi Global Markets, and of course the courts of the DIFC. Now, with this notification, any decree that is passed by a superior court is executable in India, as I pointed out, as if the decree was pronounced by an Indian court of competent jurisdiction. And the decree holder will not be required to file or institute a fresh suit in India for the same relief, as was the case prior to the 2020 notification. We can move to the next slide, please. Moving on to the documentary prerequisites. Now, the Code of Civil Procedure in Section 44A provides a comprehensive list of documents which are required in order to enforce decrees issued by reciprocating territories. The first requirement is that of a certified copy of the decree which is sought to be executed. The next requirement is a certificate from the concerned superior court stating the extent to which the decree has already been satisfied. The objective behind this provision is to ensure that the decree holder cannot seek to duly enrich itself at the cost of the judgment debtor by enforcing the same decree twice, or there being an element of overlap in the execution of the decree. Also, in the event the decree is in a foreign language, an English translation of the decree would be required to be filed. Now, as a matter of practice, in cases where a decree was issued ex parte, the authenticated copy of the summons issued to the defendant help in establishing that the principles of natural justice were followed. And I will deal with Section 13 in subsequent slides, and that is when this will become even more clear. If you could move to the next slide, please. Now, in this slide, I will try and explain the lay of the land as far as the execution process in India is concerned, insofar as foreign decrees go. Now, the Code of Civil Procedure is the mother legislation that governs execution of decrees within the territory of India, irrespective of whether the decrees are domestic or foreign. The code has various provisions which deal with execution of foreign decrees, which I will deal with later. However, the two relevant parts of the code which are relevant for us are Part 1 and Part 2. So Part 1 of the code deals with suits in general, issues such as place of suing, cause of action, etc. Part 2 deals with execution of decrees, including foreign decrees. Now, why this is relevant is because Section 13 forms part of Part 1, and Section 44, capital A, forms part of Part 2 of the code. in order for a foreign decree to be executed in India, one of the most critical requirements is that the decree must be conclusive. Now, this requirement as to what constitutes a conclusive decree is enumerated in Section 13 of the Code. And curiously, Section 13 is negatively couched in that it provides what factors, when they are present in a decree, will actually render it inconclusive. In cases where a foreign decree is sought to be executed in India, the judgment debtor who is present in India will very often try and take shelter of one or more of the provisions contained in Section 13. And I will enumerate some of these grounds which a decree holder is likely to encounter, and you or your clients might have to deal with when enforcing a UAE decree in India. The first objection that could be taken is that the decree is not passed by a court of competent jurisdiction. For a decree to be conclusive, it has to be passed by a court of competent jurisdiction according to the local laws of the foreign country where the decree was passed and the principles of private international law. Now, here it's relevant to stress that what becomes conclusive is the decree passed by the foreign court of competent jurisdiction itself, and not the reasons for which the decree has been passed by the foreign court. So the Indian executing courts will not go into the reasons or the basis on which the decree has been passed, but we'll see the larger issue as far as Section 13 is concerned. What is also important is another defense which is very commonly taken is and this defense is very critical because in India, principles of natural justice, our courts lay a great deal of emphasis on the principles of natural justice, and therefore you'll find Indian court judgments are often long drawn and going to tens if not hundreds of pages, and that is that the decree has to be on the merits of the case. If the foreign decree is not on the merits of the case, it will not be conclusive. Now, for a decree or a judgment to be an adjudication on the merits of the case, it has to meet two tests. First, it must appear from the decree that the court has applied its judicial mind to the matter. And secondly, the court that has issued the decree must have considered all the evidence that was made available to it. The court, in deciding the matter, after giving an opportunity to the parties and after considering the rival submissions, must have given its decision in the form of an order or a judgment. And it is only when the decision of the court forms part of an order or a judgment will it be held to be conclusive for the purposes of Indian law. It is also important that the decree must not be based on an incorrect view of international law. And if it does take an incorrect view of international law, it will not be a conclusive decree. However, the mistake, insofar as this point is concerned, must be apparent on the face of the record. And the court will not go into a fact-finding inquiry. It will not dissect the decree to arrive at this finding. And the finding must be writ large for the judgment to be disqualified on the grounds of Section 13. The decree must not be in violation of the principles of natural justice. I think this is self-explanatory. And like I pointed out, there's a great deal of emphasis that Indian courts lay on principles of natural justice. And it is for that reason that you have very few summary proceedings, particularly under the Civil Procedure Code. And very often you find that summary proceedings, by virtue of operation of the code, are converted into regular suits because courts lay a great deal of emphasis on hearing the defendants and appreciating evidence filed by all the parties, etc. So a judgment or a decree which is passed without issuing notice to the defendant or without affording an opportunity to the defendant to represent its case, it will be considered to be violative of the principles of natural justice and will consequently be inconclusive. However, and this is very important, a proceeding will not be a violation of principles of natural justice if a defendant does not make proper use of the opportunity afforded to it. Also, an illegal or a wrong judgment has to be distinguished from a judgment which has been passed in violation of principles of natural justice. There must be something in the proceeding, in the procedure anterior to the judgment, which is repugnant to the principles of natural justice and not subsequent to it. It is also important that the decree must not be obtained by fraud. I think that point also explains itself. If it's obtained by fraud, it will not be considered conclusive and therefore will not be executable in India. And finally, the decree must not be in breach of any Indian law. And the reasoning behind this clause appears to be that any judgment or decree which is sought to be enforced in India must not offend the law of the land. Thus, any decree, if it is enforced in India, if it leads in or results in a violation of Indian law, shall be denied to be executed. The execution of foreign decrees, as I maybe pointed out, may be resisted by the judgment debtor on any of these grounds or a combination of one or more of these grounds. And inevitably, you will find when you come to enforce a foreign decree in India, the judgment debtor will take the grounds of jurisdiction, a competent court, fraud, and so on and so forth. Unfortunately, the word fraud is taken very lightly, and you'd find the word fraud being used far more freely in India than you would in other jurisdictions. Having said that, I do need to point out that the burden of proving the existence of these grounds lies on the judgment debtor itself and not on the decree holder. And so the decree holder has a presumption going on in his or her favor. And this is further fortified by the presumption, another presumption which is contained in section 14 of the Code of Civil Procedure, which states that when a certified copy of a foreign decree is produced before an Indian court, which is the executing court, the Indian court shall presume that the judgment was pronounced by a court which was competent to decide the issue, and it was passed by a court of competent jurisdiction. Now, this is as far as the issue of conclusiveness of the decree is concerned. With that, I will segue into some practical challenges that a decree holder is likely to face when executing a foreign decree in India. Now, these are experiences that that we have come across, challenges that we have faced in court, and almost every foreign party that has sought to or has tried to enforce a decree in India will have similar experiences as ours, and we've tried to put together a short list which we thought might be helpful to you. The first requirement would be to have the presence of a local authorized representative in India. Anybody who's had litigation experience in India will tell you that not just execution proceedings, but any litigation proceeding in India requires active involvement of the litigant at every stage. So, for instance, all applications are required to be signed by the litigant. They have to be signed in the presence of an oath commissioner or a notary public. They can be signed to an authorized representative, but then the burden would shift to the authorized representative rather than the individual. There is a repeated need for the litigant or the representative to appear in court to give evidence, to accompany the court staff for service of summons or for attachment of properties and the like. And traditionally, Indian lawyers cannot assist or provide any service beyond the actual court process. And the client is expected to handle everything beyond the actual court process, which is different from many other jurisdictions that I've been given to understand. Another issue that is often faced while executing a foreign decree in India is identification of properties. Now, the decree holder seeking execution has to provide and is expected to provide complete details of the properties owned by the judgment debtor and procure ownership documents from the government authorities or from the concerned authorities for the courts to proceed with attachment and the sale of properties. So courts in India often do not go into this exercise where they would go into a fact-finding mission and ascertain the assets of the judgment debtor. However, if certain evidence can be produced by the decree holder, the courts would obviously take that into consideration. Another challenge that is faced during execution of these decrees is the attachment of properties, because the attachment of properties is a very tedious process in India, much like many other jurisdictions. And it requires active involvement of the decree holder or its representative. It would involve multiple trips to the concerned authorities that are issuing the attachment certificates. It would require arranging police protection so that possession can be taken, whether actual or constructive. It will involve arranging storage of storage spaces for movable assets, valuation, and the list is endless. Another issue which has become even more relevant now that there is a limited recognition of personal insolvency in India is identifying the solvency of the judgment debtor. Before initiating enforcement proceedings, particularly in money claims, it becomes extremely important to ascertain the financial background, assets, etc. of the person against whom the judgment is sought to be enforced. And therefore, identifying the solvency of the debtor is extremely important for evaluating success of execution action. And I don't need to mention here that this is equally important in case of companies now that since 2016, we have an insolvency code which is extremely active, and we have a dedicated court which is enforcing the provisions of the insolvency and bankruptcy code. Finally, tracing the debtor is another very important component and often a challenge that parties have to face. Filing an execution petition is futile if the debtor is not available at his or her last known address. And therefore, tracing the whereabouts of the debtor is very important for obtaining results. These are just some of the challenges that we have come across in enforcement of foreign decrees. Just one last point on this slide. While the period of limitation for execution of a foreign decree in India is 3 years, if the decree holder has initiated execution proceeding in any other country and the decree has not been fully satisfied, then the decree holder shall have the right to apply. Then the date from which the right to apply shall be counted would be the date on which the execution proceedings in the cause country came to an end. So you essentially get an extension of limitation from that date.
Thank you, Abhishek. That was indeed very helpful. So moving on from how Section 144A lays the process on the courts and all the aspects that Abhishek talked about, it is important to understand, and that lays the context for our next slide, which is that the 44A deals with the direct enforcement. Now, once you have extinguished that option, what can you do? So then the IBC regime, like we spoke about, comes into play. But before we start talking about the IBC regime vis-a-vis enforcement, or rather filing an insolvency against a debtor in India by any entity outside of India, is we should understand the NCLT, which is the National Company Law Tribunal. It is not an execution court. So we should be clear that this tribunal, we do not enforce for execution of a decree. Rather, this is only for if should the guarantor or an Indian party fail to pay its dues, the dues which are due and payable, that are the two parameters of the law. This is when this forum can be knocked at and we can approach this forum. Now, before we begin this, the slide that I will be dealing with right now is on the IBC regime vis-a-vis a personal guarantor, which is based in India. The slide which you see in front of you lays down the process, the broad process on how this option can be invoked. The first one of which is the insolvency of guarantee and the notice to the payee. The first is that the party holding the guarantee has to invoke the guarantee. What we mean by invoking the guarantee is we have to send a notice to the guarantor for asking for the payment within 14 days, which is the law which is prescribed under, which is the timeline which is prescribed under the law. If the debt is not paid, the decree holder files an application before the NCLT. And this application is, what happens in this application is the IBC processes in India are adjudicated, are overseen by a professional, which is a resolution professional. That is a court appointed intermediary which oversees the process. We will seek for appointment of that intermediary, and we will also primarily and also seek for invocation of an interim moratorium. What we mean by an interim moratorium is any new legal ongoing cases against that personal guarantor would be stalled. Once we file this before the NCLT, the interim moratorium on new and ongoing legal actions against the debtor is invoked. And then the NCLT also prescribes also orders the appointment of the RP. So once the RP is appointed, the resolution professional, as I mentioned, the role in this context of the resolution professional is to review the application, the grounds on which the guarantee holder wants to file an insolvency proceeding, and basis such review, the RP recommends admission or rejection of the decree holder's application. Those admission or rejection grounds are filed before the NCLT further. Then the NCLT assesses such grounds and either accepts or rejects the application basis on the resolution professional recommendation. Now, if the application is accepted, the moratorium on then comes the final moratorium, which is the moratorium on transfer and encumbrances of the debtor's assets is imposed. which is followed by a public announcements published for inviting claims. When we say inviting claims, we means any other claims which any other party may have against the personal guarantor, because the insolvency, we should be mindful about the fact that when it is not a direct enforcement and we are approaching the IBC, the resolution that happens here is not only vis-a-vis a guarantee holder from UAE, it will happen for all other claims that any party may have for this guarantee holder, for the guarantor. Then the guarantor base, once the public announcement is done, the claims are, the claims are received, that collation happens. After that, the guarantor submits a plan for restructuring its debt in consultation with the RP. Post which, and this restructuring plan, what it sought to achieve is that it will try to address all the claims that have been filed before, filed against that guarantor, which will also include the claim of the UAE holder, guarantee holder. And also this plan, there are guidelines and guidances in the law, which is the IBC code, which will determine on how this plan has to be formulated. That once such plan is submitted, the creditors, including the UAE party, will accept or modify the restructuring plan. Should they accept the plan will be presented by the creditors before the NCLT. Now there are also guidances on how the NCLT, now the NCLT will also, approve or reject this plan basis on evaluation and tallying it with all the parameters provided under the law. If approved, if such plan is approved, the RP, the resolution professional, supervises the implementation. And should that plan be rejected, the guarantor goes into bankruptcy and the assets are sold. So what we try to achieve, so the bottom line of this process is that if we are unable, or rather if we don't get a favorable order for a direct enforcement, this process is also open to guarantee holders from UAE. Thank you, and I think we can move on to the next slide.
So I will not explain in any greater detail than is written on the slide the regime in India as far as corporate insolvency is concerned. Akira, you could just turn to the next slide, slide 10. It's titled Insolvency Laws. Yeah. So insofar as the corporate insolvency resolution process is concerned, the process is not substantially different from the process for personal guarantors that Namita dealt with. And I will not go into that because the corporate insolvency resolution process is based on the UNCITRAL model law and is not substantially different from the insolvency process that you may find in your home country. However, I would like to state that one of the main objectives of the code in bringing the insolvency law in India was to put everything under a single umbrella with the object of speeding up of the insolvency process, which wasn't the case prior to 2016. Briefly, the code provides that where any corporate debtor commits a default, a financial creditor or an operational creditor or the corporate debtor itself may initiate corporate insolvency resolution process in respect of its debts in the manner as is provided in the code. Now, the NCLT has held that it does not have the authorization to enforce a foreign decree because the NCLTs or the National Company Law Tribunal, which is the court where the insolvency matters are run, is by its very nature a summary court. Nevertheless, there is no specific regulatory provision which would preclude the NCLT from taking cognizance of a foreign decree. In fact, the National Company Law Appellate Tribunal, in one of its decisions in the case of Usha Holdings, has held that the NCLT cannot deliberate on the validity or legitimacy of a foreign decree in India when admitting or rejecting a claim as a debt under the IBC, since it is merely an adjudicating authority and not a fact-finding body, as I just mentioned. Now, there are some other case laws which suggest that the tribunals constituted for the purposes of discharging powers and functions under the code may take cognizance of a foreign decree and treat it as a debt for the purposes of triggering the code. In fact, the NCLT in its decisions have taken note specifically of Section 44 capital A and Section 13, observing that there is a prima facie case made out under the code and a debt is payable. In this view, reciprocity between India and UAE for the execution of decree under Section 44A of the code would give credence to foreign decree holders to invoke the mechanism under the Insolvency and Bankruptcy Code as a measure of debt realization. So even though very often it might be an operational debt, and for those of us who are familiar with the insolvency process will know that it's highly unusual for operational or creditors to get a substantial part of the debt, but very often the threat of initiation of insolvency is in itself an effective tool to get the other side to conform with the decree. Now, some may also argue as to whether the IBC recognizes a distinction between decrees from non-reciprocating territories versus decrees from reciprocating territories from the standpoint of the debt. Now, this is substantiated by the fact that enforcement of a decree which is passed by a non-reciprocating territory will entail filing of a suit, as I stated earlier. Now, this filing of a suit can itself lead to the corporate debtor taking an argument that there is an existence of a dispute between the parties, and therefore there is no question of an admitted debt and consequently of default in payment of the admitted debt. You can move to the next slide, please.
Abhishek, before we move on to the next slide, as I mentioned in the introduction, in our experience, quite a significant number of debtors in India abscond from the UAE, and these are individuals. In this regard, my question to you is, under the Indian bankruptcy law, is there a distinction? And does it apply to both individuals and corporates?
Thank you, Sergejs. That's a very important question. So even though the Insolvency and Bankruptcy Code was notified as far back as 2016, the provisions of the code which stand notified are provisions which are confined to initiation of insolvency against corporate entities or companies. The only limited extent to which provisions of the Insolvency Code would apply to individuals is that they, since December of 2019, if I'm not wrong, the provisions of the code which deal with initiation of insolvency against individuals who've acted as guarantors to a corporate debtor. So if I'm an individual who's extended a personal guarantee in respect of a company which has gone into insolvency or which has defaulted, then the creditors can enforce insolvency proceedings against me. But on a standalone basis, if there is no guarantee extended by me, the provisions of the Insolvency Code will not apply. So the answer to your question is yes, technically, the Insolvency Code does apply to individuals, but in a very limited, in a very narrow manner. I hope that answers your question.
Yes, thank you so much.
Abhishek, one question from me, if you don't mind.
My pleasure.
In case of approaching the insolvency courts while executing the judgment, does it mean that we do not approach the district court?
I think the way in which the regime works is you first approach a district court and get the decree executed. It is only upon the execution of a decree that it takes the shape and form of a decree which is akin to an Indian decree. And rather than enforcing the decree and attaching of assets or realizing the assets, this decree could then be carried to the NCLT and used as a piece of evidence to point out an admitted debt and a default. So execution would anyway be a necessary step.
So you would need to approach the district court before you get to the NCLT.
That is right.
And a related question to that, and this is a query which we posed by several clients, is country size of India with so many district courts. How do you determine which is the relevant district court where you initiate proceedings?
Oh man, that's one of the most important questions, if not the most important question in any enforcement action. So while Indian courts have the power to transfer a proceeding to the relevant court, this process of if you end up in the wrong court, you're going to lose a considerable amount of time in just arriving at the right court. So even though as per the Civil Procedure Code, the suit can be filed in either of two places. It can be filed where the defendant resides or carries out his or her business, or it can be filed where the assets are located. And it's obviously more expedient to file in the court where the assets are situated. And Indian law also has a provision where you may file in a court where a substantial part of the assets are situated, and the orders of the court will then follow, and they will ensure that you do not have to jump from one court to another to actually get the fruit of the decree.
Thank you. So what it ends up meaning is that if we start proceedings in the wrong district court, the entire proceeding fails.
Oh, absolutely. And especially if you consider the delays in the Indian legal system. I mean, it'll probably be 2 years before you realize you're in the wrong court.
Got it. Thank you so much. You can continue with your presentation.
Abhishek, I would just add one point to the first query Manish asked. So just to substantiate and add just a minor note to what Abhishek rightly mentioned on the first query. So it is absolutely right that you have to first go and enforce it in the district court. Basically, just to give context to you, Manish, first as per the IBC, any amount has to be due and payable. So when it happens is when you have an order that this amount has to be paid to you within X date. So once you go to the district court, you put the superior court order, you get a favorable order that from the district court that the amount has to be paid within X number of days. Then when it is not paid is when you can go and invoke the IBC, because like Abhishek already rightly mentioned, is that the NCLT is not the enforcement court. It is just a court where you will go and adjudicate your insolvency proceedings. So therefore, your first trigger to initiating insolvency is the amount has to be due and payable.
Excellent. Thank you. Thank you so much.
Thank you. If Abhishek, can we move on to the next slide?
Absolutely. Over to you, Namita.
Thank you. Yes, so on the next segment, which is the next 3 slides, we will be looking at a case study, which Abhishek has already mentioned in the case of Usha Holdings. Why this case study is not an apple to apple. It's not an absolutely similar facts that where an UAE creditor was trying to, enforce a judgment in India. But what we are trying to draw a similar parallel is when a decree holder from the United States had come and approached the NCLT for recovering, for initiating proceedings and for recovering dues. And this judgment is important because it gave the landmark to the principle which we have already talked about, is that the NCLT is not an enforcement court. It is a court where you come and adjudicate the insolvency proceedings. So and what we are trying to achieve by highlighting this case law is that how this notification will further give a straightforward route of direct enforcement. And then you come to the NCLT if that direct enforcement requires so, or rather if you are not able to recover your dues from such direct enforcement, that's when you go for an insolvency. So the facts of this case was that an appeal was preferred by Usha Holdings against an order of NCLT's principal bench, where NCLT rejected the initiation of corporate insolvency resolution process of the corporate debtor, which is a FranCorp Advisor Private Limited, on 2 grounds. The ground was that the decree is not passed by any superior court of a reciprocating territory, which brings us to the main principles of Section 44A, which we already spoke about. And also that the foreign judgment is not conclusive as it is not pronounced by a court of competent jurisdiction and is founded on an incorrect view of international matter. So here, if you see the 2 grounds why we are trying to emphasize this more, is that this brings us to the principle which we have been speaking all through in this presentation, is that when you get an order to the Indian courts, it has to satisfy these criteria. And later, like I already mentioned, we will further delve into whether NCLT is the right forum to go or the district court, and which will further be related to the fact that what Section 44A process says on a direct enforcement and whether or not NCLT is the right forum for that. In the present matter, the appellate tried to initiate the corporate CIRP of the corporate debtor under Section 9, which is the main section for initiation of one of the sections for initiations of insolvency, on the basis of the decree passed by the court in United States, like we said. and which was rejected by the principal bench, to which pursuant to which they went to NCLAT, and the grounds of rejection by the NCLAT we have already mentioned. Now, what were the contentions of the respondent here? So these are very important to note, because this also brings us to the fact on on how our objections raised in similar matters, which was one of the queries in the previous slides. The foreign decree is an ex parte judgment, and the said judgment and decree cannot be treated as a decree on merits, which brings us to the fact that as one of the primary tests, the decree has to be, which we are presenting, has to be on merits. No findings have been provided as to how the sum is due and payable, and amongst which the main points were: the decree is the nature of an imposing penalty. The appellant does not hold any money decree in its favor. The order which was being presented was only declared as a preliminary objection with regards to the jurisdiction, defective services of summons, lack of personal jurisdiction, and doctrine of non-convenience. An order of the court is entirely based on an unsigned commercial agreement, which further leads us to the fact that the agreement on which we are trying to seek any recovery or amount has to be a validly executed document, and also that the commercial agreement provides for arbitration, and therefore the recourse used by the petitioner was not in line with what has already been commercially agreed. And also the NCLT has no jurisdiction to decide the legality and validity of a foreign decree, and no right finding can be given by the NCLT, which is again brings us to the main point which we have been speaking about, that the NCLT does not have jurisdiction of enforcement, rather it only adjudicates insolvency proceedings. If we can move on, please. Now, the judgment which was given by the NCLAT now forms one of the key ratios for similar matters, is that the NCLAT here relied on the Binani Industries versus Bank of Baroda order, and it held that NCLT, not being a court or tribunal, and it has only adjudicates insolvency, and it has no jurisdiction to decide whether a foreign decree is legal or illegal. Point being, NCLT cannot decide on the merits of the case. The merit already has to be established by a district court in the current proceedings. And whatever findings the NCLT has given with regard to legality or proprietary of foreign decree in question without jurisdiction is null and void in the eyes of law due to the similar reasons. Further, NCLAT also held that the appellate does not fall within the definition of an operational creditor, which is one of the key, under the IBC, there are two distinctions of being a financial creditor and an operational creditor. To initiate proceedings, we have to also keep in mind the due processes that have been laid out by the IBC, which is again further reiterated by NCLAT here. And therefore, this Section 9 application filed by it is not maintainable. And in view of all of these grounds, the NCLAT upheld the order of the NCLT and dismissed the appeal. Thank you. And if we could move on to the next slide, please.
Thank you, Namita. So coming back to the question, what has changed? Now, as I pointed out before, prior to the January 2020 notification, even though there was a 1999 bilateral agreement between India and UAE, the cooperation between the two countries was extremely limited, and it was confined to issuance of summons and taking of evidence by way of letters and so on and so forth. And consequently, a UAE decree was no different from the decree of any other non-reciprocating country, whose execution would have required filing of a suit and leading of evidence. Pursuant to the notification of UAE as a reciprocating territory in January 2020, decrees or orders from the notified courts in UAE can be executed directly before courts having appropriate jurisdiction in India, and they are virtually, for all intents and purposes, treated akin to domestic decrees. Also, and this is very important, such foreign decrees or judgments will operate as res judicata, except in the 6 cases that are specified in Section 13 that I dealt with. So the res judicata is something that will be available, which was unlike the post 1999 and pre 2020 regime. Now, the 2020 notification has made the process of execution of decrees considerably simpler and in fact summary in nature. But most importantly, the time period for executing decrees passed by the notified courts in UAE and in India will be considerably reduced, and so will the costs involved in the process. So I think that's the biggest takeaway and the biggest benefit of the 2020 notification. Over to you, Namita.
Sure. Thank you, Abhishek. So now, as the last point which we had mentioned is in light of, and I can see a couple of queries on the IBC front, which we will obviously address once we conclude the presentation. Now, on the last bit is, now we understand what this Section 44A notification does, what are the recourses that we have. But in preemption to that, when business houses are entering into contracts, what should we be mindful so that tomorrow, from a contractual perspective, there is no hindrances in us approaching the direct enforcement? Now, like also to substantiate that, if you in the last slides when we talked about the case law, we noticed that the courts also rely on what, and the opposite party will also get grounds if we do not comply with the contractually agreed mechanism. So therefore, it becomes important for us to see how should we formulate our contracts in light of this notification. The key point here is that the jurisdiction clause of an agreement should be absolutely clear. And also the dispute resolution clause should be absolutely clear. The point is, if we have for instance, if we have an arbitration mechanism before going to the courts, that should be extinguished. Secondly, now on the jurisdiction clause, it should be clearly stated that the jurisdictions shall only be of superior courts, for the simple reason on what we have spoken about, that 44A only recognizes superior courts. Then there are some other points to be noted in this context is vis-a-vis the UAE law, is that the relevant law of UAE should not be in breach of the Indian laws. And some of the examples we have already discussed. Then proceedings should not refuse to recognize the law of India in case of which such law is applicable. Further, the jurisdiction should be submitted to only the courts within which fall under the ambit of the superior courts, like we mentioned. The court adjudicating the matter should be of competent jurisdiction. The matter should be decided by the court on merits of the case. And the decision of the court should not be in contradiction or derogation to any international law. The proceedings should be conducted in compliance with the principles of natural justice, and the order of the court should not have been contained by fraud. Now, point is that what we are trying to make is, if you notice, all the aspects which we have divided in our presentation ultimately leads back to what are the threshold of Section 44A. So the point we are trying to achieve here is, when we are formulating our agreements now, we should be mindful that there should not be any language, or rather we should have enabling languages which helps an UAE party to come and approach for direct enforcement under Section 44A, which brings us back to all the parameters that Abhishek has also mentioned, that these should also be kept in mind when we formulate the agreements, and also when we try to enforce, or rather have a decree in UAE itself, so that the decree can be brought to India and directly enforced under Section 44A. Thank you.
So Manish here, in the interest of time, I think we can open ourselves to the question and answer sessions. Are there any questions on your chat box? Because I need to open my chat box too.
Hi, I see a couple of questions here. If I may proceed, Manish, with your permission.
Please, definitely, for sure.
The first question is from Arshia Munir, and it says, can you give us an indicative figure on the court fee applicable for initiating enforcement of UAE judgment in India? If Namita permits me, I can perhaps take that one. Arshia, the answer to your question is, there is a fixed court fee which is payable on execution petitions in India. Now, this court fee varies from state to state, but in any event, it's an insignificantly small amount. So I don't think a decree holder would be concerned with the amount of court fee payable on an execution petition. But you must keep in mind that this issue is relevant for enforcement of a decree in a reciprocating territory. The moment you need to enforce an award in India, which is issued by a court which does not form part of a reciprocating territory, you will have to file a suit for enforcement of that decree. And you will have to pay ad valorem court fee on the valuation of that suit. So I hope that answers your question. For reciprocating decrees from reciprocating territories, court fee is not ad valorem, and it's a very small amount. But if you have a decree from a non-reciprocating territory, you would have to pay ad valorem court fee on your plaint. The next question, if Namita, perhaps you could take this. This says,
Sure.
correct me, and I unfortunately I can't see the name of the person who's raised this question.
Yeah.
It says, correct me if I'm wrong, but
Yeah.
after insolvency proceedings, how can the execution be effected towards recovery if NCLT is not an execution court? Do we need to go back to the court for execution?
Right. So thank you, Abhishek. So I'll take this one. So I think let's take a step back and let's understand that what we are trying to say is execution of a foreign decree. We should be very clear that it is under section 144A of the CPC, and IBC is a different mechanism in itself. Now, why we are relating these two concepts together is because when you want to do a direct enforcement, you go set to section 44A. Now, under section 44A, when you have an order that you have a valid order that you can recover this amount is due and payable to you basis your UAE order, then that becomes your order which needs to be enforced. Then you go and find out the processes on what we spoke about on finding out the assets, asking for recovery. Now, if that amount which is payable to you under that order from the district court, if that is not paid to you, that is when IBC comes into the place. You can now, if IBC wasn't there, you would have to, that the process of enforcement would have been longer. Now, if within that stipulated time, if you are not able to recover your funds, you knock on the doors of the IBC because your amount has been due and payable and it hasn't been paid. So that nowhere makes an NCLT an enforcement court. The enforcement court is the district court, and now you're coming to NCLT because your amount hasn't been paid, which was due to be paid to you. Now the process of insolvency starts. At the end of the insolvency, if there will be a restructuring plan. So there is two scenarios possible. Either you are pursuant to the restructuring plan, your dues are paid, or if it is not paid, then the bankruptcy of the personal insolvent, in that case, if that's the case, that happens. If it is a corporate, if it's a corporate, then of course a liquidation will happen and your amounts will be appropriated and received back by you in the manner provided in the IBC code. So the distinction, and to answer your question squarely, is when the IBC does not pass an order which is to be enforced, like you have to go back behind somebody and recover the money. That order is by the district court. That is why the district court is the forum for a direct enforcement, and insolvency comes into the place when that person is not able to pay to you. That's when you initiate the proceedings under insolvency. I hope that is clear.
Thanks, Namita. Namita, I think that sort of dovetails into one more question that we received. That is, can we directly submit the judgment in any high courts for execution? I think you answered that question. The answer is no, and that the decree would have to go to a district court, right? I mean,
yes,
do you want to elaborate, or do you think that answers the question?
Sure. So like Abhishek, you're absolutely right. And why it has to go to a district court, I'll take again a step back and go back to section 44A. Point is, when we are doing a direct enforcement, like we said, there are parameters to it, which is provided under section 44A itself. Like they have superior courts from the courts which are eligible, whose orders are eligible to be enforced in India. The Indian counterpart of a valid forum is a district court. So therefore, you cannot directly go to a high court, which is a higher forum and for enforcement of your order. And your first forum to be knocked at is your district court, which is the identified forum under section 44A. Point being here, like we are the point which we are trying to emphasize here is the process of direct enforcement is per section 44A, and the concepts which comes into the play, which we have to understand here, are the concepts which Abhishek spoke about in the beginning. That is the valid forum for knocking the door, which is a district court, the superior courts whose orders are valid, so on and so forth. Thank you, Abhishek.
Thanks, Namita. We have another question from Nikhil, and I will attempt to answer this one. The question is, can a decree holder from an Omani court get its decree executed in India through UAE courts rather than directly approaching Indian courts? Well, Nikhil, I must very candidly admit that I am not aware if there is if there is a decree or a bilateral arrangement between Oman and India. But having said that, my reply, of course, it's subject to deeper examination, is no. It does not seem that that would be possible. However, in a scenario where there is a decree by an Omani court, and I'm not aware if there is any similar agreements between Oman and UAE as there are between India and UAE. You perhaps could go, if there were such an arrangement, you could perhaps go to a UAE court and exercise those rights. But as far as Indian courts are concerned, I'm afraid the answer appears to be no, because the reciprocating territory concept recognizes specific courts of the UAE as superior courts. It does not extend to Omani courts. We have another question from Manish, where he asks about the identification of judgment debtor assets. That's a tough one to answer. But as I stated in the presentation, there is no formal mechanism which is available, at least no state-owned mechanism or agency, an authorized agency or an organ of the judiciary which would enable a decree holder to carry out this exercise. However, over the past couple of years, there are a large number of private service providers who have come up, who carry out this task, who identify assets, and who help decree holders zero in on the assets which can be used to execute decrees by way of attachment and so on and so forth. I hope that answers your question. We have another question. I don't know if you have the time to take more questions, but we have at least two or three more questions.
I've been told by our technical staff that we can go on until 12:15, and at 12:15 automatically we will all be disconnected. Therefore, please, you do have a couple minutes yet to answer any further questions. Thank you, Abhishek.
Thank you. I'll try and take at least two more questions while I can. So there's another question here which says, from Mr. Vinod Kumar, which says, while the execution order is being executed by a decree court, can the other party file any appeal in High Court and stop the execution proceedings? Well, if there is any interim order which is issued by an executing court, perhaps such order could be challenged by way of an appeal. But the mere filing of an execution proceeding may not give a right to a judgment debtor, in my view, to carry the proceedings in appeal. I mean, that of course would also depend on the facts of each case. If I can take one more question from Mr. Manoj, it says, if the debtor resides in one district and his assets are in another district, which court do we have to approach? So in a scenario like this, if I were to advise a client, I would advise the client to file the execution petition in the district where the assets are located, because then there are not issues of transfer of this proceedings to the appropriate court and so on and so forth. And the whole idea behind filing of execution proceedings is to obtain recovery by way of the appropriate means, and filing a proceeding in the district where the assets are located would also make it easier for the concerned court to pass attachment and other relevant orders. If I could take just one last question from Mr. Thomas. The question says, in GCC, normally court process is in three phases. That is, first court appeal, Court of Cassation, then only a judgment becomes final. So how will the court-listed reciprocal treaty work as far as the UAE judgment is concerned? I'm afraid I'm not able to understand the import of that question. Mr. Thomas, if you could clarify that in the chat box, that would be very helpful.
If I may intervene with your permission, Abhishek?
Absolutely.
To answer that question, I think, see, how it works is the court of first instance, then there's a time period allowed for appeal. If no appeal has been filed within the time period, the court of first instance judgment then proceeds for execution. So I think the key here is, when is the judgment becoming executable for purposes of then moving for enforcement within India. Does that answer you?
That's right. That's right. Namita, I believe you had addressed this point in your presentation in one of the slides.
I'm afraid that we will need to be wrapping this webinar up. Thank you for everyone for attending. And I think Manish may have a couple words to say in conclusion. Microphone, Manish. Microphone.
Sincere thanks to Namita, Abhishek, Sergey, and very importantly, all the participants. Just following the questions tells us that there's still a lot of complexity when it comes to enforcing a foreign judgment in India, in spite of the treaty, and that's true for all jurisdictions. Moving forward, we will continue to work with our Indian associates and counterparts to build bridges so that we can provide effective enforcement advice to our clients in the UAE. Thank you. With that, I think it can be signed off.
Thank you. And just one final thought. If you have any further questions, please don't hesitate to email us at the emails that you see or at info@galadarilaw.com.
Thank you. Thank you so much for having us.
Thank you so much.
You're welcome. You're welcome.